wonder whether there isn't a broader principle at stake in a case like Haven's. I mean, here your client has disclaimed, has said, I'm not intending to go on vacation at all. I'm not intending to go to any hotel. I'm not intending to use the reservation service at all, to look for accessible hotels, to reserve at accessible hotels, to go to accessible hotels. I'm not doing any of that. So tell me how she is discriminated against by the inaccuracies on this website.
The reason that the case comes to the court in that posture is because injunctive relief is so elusive when you're talking about concrete travel plans. As was noted earlier, Ms. Laufer did amend her complaint in this case to say that she was going on this long road trip. But when the case was on appeal, she had already gone on the road trip. And so that's why when we say she's disclaimed any intent of going on a trip, it's because by the time the case was on appeal, she had already gone on the trip.
Well, that's the case that's before us. It's a case that before us with a stipulation that she's not using the website for any vacation purposes. But that she's, and I think that your brief reads like this too, that the harm is, well, I'm not sure. You tell me. The harm is just, I'm a person with a disability and I see that there is inaccurate information about accessibility, and that itself harms me even if I have no plans or less than plans. I'm just not thinking about vacations at all.
Yeah, so I'll start by saying that the reason all of these tester cases, or really any of these reservation rule cases, are going to be in that posture is because you can't have concrete or even somewhat concrete travel plans and get an injunction in time. So that's why these cases have been just generally litigated in this way, in this pure tester posture. But the injury here, again, it's not just a denial of information. The day-to-day experience of being a disabled person is to have your world be very small because our marketplace, our places of public accommodation just ignore you. They don't see you. They don't recognize you as a potential customer or as a member of the marketplace. And so when Ms. Laufer goes to the website and she sees that she's invisible, that they are not even acknowledging
her. Well, suppose she goes to the website and rather than look at accessibility information, she goes to the website and she looks at lots of pictures of places and says, oh, this one doesn't have the required ramps. And again, she's not going to those places. She has no intent of going to those places, but she sees that they don't have the required ramps, and she brings suit then. Does she have standing to do that? Because I think that that's pretty similar to what is going on in this case.
So she does not have standing based on the pictures because she's not encountering the accessibility barrier herself.
Well, I don't know. It's like right there. I mean, if you're saying it's how you experience discrimination, and I can understand that, but I'm experiencing that sense of being excluded when I see that all these hotels are set up to exclude me and others like me.
There might be some sort of Article 3 argument there, but Congress certainly hasn't provided a cause of action there unless you actually have plans to go to the hotel. And I want to go back. I think